Good afternoon, everybody. This is Dan Frier, and I thank you for joining us this afternoon. There's still people coming in, but I wanted to start on time for those who did make it on time, and we'll admit anyone else who comes in afterwards. They won't miss too much. Today, we're going to talk about how to protect your medical practice from regulatory and criminal exposure. This is not a lecture about medical malpractice liability. This is a lecture on the pitfalls that that can face practicing physicians and other healthcare providers that involve regulatory concerns, statutory concerns, potential criminal exposure, and we're going to get into a pretty deep analysis of this. This is not a cursory discussion, and at the end, you'll be able to ask questions and submit your questions, and we'll try to get to as many of them as we can during the course of this webinar. So thank you so much. The only thing I'll say about the disclaimer, we're lawyers, we have to have disclaimers. We are not providing legal advice to anybody on this webinar or afterwards. Anyone listening to this webinar, we're not acting as legal counsel, even for those of you who may be our clients. For purposes of this webinar, we are not your attorneys, just providing information for everybody. So for those of you who don't know Frier Levitt, it was established in 2000. I'm one of the two founding partners, and we've grown into a national boutique healthcare law firm. We have about 45 lawyers. I bring this up. This is not a marketing video. This is really for substance. I want to give information, but I also want you to understand the perspective that I'm coming from and that my partner Anthony's coming from. We've been in healthcare our entire careers, and we've seen almost everything you can possibly imagine over and over again in different iterations, different generations, and we'll be talking about some of those things today. I'm not going to talk much about ourselves. Anthony will give a little bit of his background. He's got an incredibly impressive background that I think is relevant to what he has to say today. So what I'm going to be focusing on is I want to talk about different types of transactions that I've seen medical practices, other providers unwittingly get themselves involved in, and then find themselves in potential trouble or jeopardy. Because a lot of the transactions that are out there, there's so much money in healthcare right now, and there's so many players. Some of them are good, and some of them are not good. There's so many opportunities to do wrong, many more opportunities to do the wrong thing than the right thing, unfortunately. And in any one transaction, there's a dozen ways to do it wrong, and usually one or two ways to do it right. And unfortunately, we see a lot of things after parties have already gotten themselves deep in a hole. Either they're involved in a transaction that they realize is not legal, or they're involved in a transaction, they're concerned they're going to be investigated, they're involved in a transaction, and they have been investigated already. You see this too frequently. So really what we're focusing on today is how to avoid that and the telltale signs of those kinds of transactions that can get you into trouble. So I have 3 slides here remaining for me, and each of those slides is going to list a type of transaction that can cause issues. I'm not going to talk about every single one of these in depth because it can probably take me an hour just to go through those, but there are a few things that I really want to focus on. So one of the most common types of transactions that I see in healthcare involves a lease or a sublease arrangement between a referral source and a referral recipient. When someone who is, let's say, receiving a referral owns a space or rents a space, an office space, they may be approached by a medical practice or a lab or some other healthcare provider that is in a position to provide referrals or receive referrals from the physician or the practice that owns the space. So let's say you have a primary care physician who rents a piece of office space out and has some extra rooms there and wants to see if he or she can sublet it to, let's say, a gastroenterologist or a lab or a mobile imaging company. Company approaches him sometimes or her and offers to pay $5,000 a month. Great, the primary care doctor is thrilled because that practice now has $5,000 of income that they wouldn't have had before and basically no cost associated with it. And the problem with this is that in many cases, that financial arrangement constitutes a kickback. And the purpose of this talk today is not to get into the in-depth discussion of what the anti-kickback statute is, what the Stark law is. That's a different topic, and that would take its own webinar. But really, the purpose of my discussion today is really to advise you and give you enough information so that you know what to be on the lookout for, and you know what you don't know. And then you can identify potential problems. So almost every sublease arrangement in healthcare where one party refers to another has to be reviewed for regulatory compliance. If you were to enter into a transaction where you sublet space to a referral source, the general inclination is to do some rough math and figure out, okay, well, I'm not willing to do it for less than $5,000 a month. The Office of Inspector General, which prosecutes healthcare fraud, the OIG, as it's referenced, they have a very specific rule with regard to sublease arrangements. They will not allow a referral source to charge essentially more than what their actual pass-through costs are. And that means that they have to follow basically this kind of convoluted formula that the OIG came up with to ensure that the referring doctor isn't subletting for more than fair market value. You can get into trouble not only for failing to sublet for more than fair market value, you can get into trouble for subletting an amount of space that is not commercially reasonable. A subtenant that only needs 1,000 square foot of space 1 day a week should not be renting 10,000 square feet of space 5 days a week from someone that they receive referrals from, because that would not be considered commercially reasonable. And I'm spending a lot of time on this particular topic because the concepts are the same in many of the things we're going to talk about today. This idea that there has to be an arm's length, fair market value relationship between referral source and a referral recipient, and that there has to be a commercially reasonable relationship between the two parties on top of the fair market value requirement. So the next bullet point I'm going to talk about is marketing arrangements. I won't spend too much time on this, except to say that whenever a third party is providing patients either through direct marketing, through internet marketing, through a listserv, anything like that, anytime a third party is providing patients in any capacity to a medical practice, the OIG has taken the position that it's likely that marketing constitutes a referral under the law. It's not a traditional referral where one doctor refers a patient to another doctor, but it is considered a referral under the law. So that, for example, if a doctor pays a marketing company a percentage of the business that the marketing company generates, that is likely going to be considered a kickback, because the marketing is a referral and the payment back to the marketing company is remuneration in exchange for that referral, which is a kickback. And this can take place in many, many forms. Any type of marketing arrangement, a website that wants to promote a particular product and wants to have an arrangement with a medical practice to provide that product, it sounds on its face, or it looks on its face like it's a completely reasonable transaction. Problem is that very often what's really happening is the doctor is paying for exclusivity within a certain geography in order to get referrals for those modalities. And in fact, not paying for the modality itself. I see these all the time. Very often we'll have clients that send us a contract and say, hey, Dan, can you review this contract and let me know if I can sign it? And they're not even thinking about a regulatory issue. They're thinking, just from a business standpoint, I want to make sure that I'm not being locked in too long, that it's not unreasonable from a financial standpoint. All that stuff's important. But the first thing we look at is, does this transaction create a potential illegal scheme between the parties? And what I've found over the years is, which amazes a lot of people, is that even reputable companies, even companies that are known in the industry, can approach medical practices with a transaction that is completely indefensible from a regulatory standpoint. So just because someone seems polished, just because someone has a decent reputation in the industry, they may not even realize that they're doing something in violation of the law, partly because it's possible they haven't had competent regulatory counsel. They've been sticking more with general business counsel. But I've seen really reputable companies approach my clients with arrangements that are patently, unlawful. And that leads to the next bullet point. any contractual relationship with a laboratory. And this hits on a number of bullet points, but I think I'll cover them all in one. So the laboratory industry is one of the most highly investigated, suspect, problematic parts of healthcare. There are many very, very reputable, good, honest, law-abiding laboratories, and we represent many laboratories. The issue is that the government has spotted laboratories as being problematic, and any relationship that a medical practice has with a laboratory should be subject to intense scrutiny. And I think the reason there's been so much issue with laboratories over the years is that laboratories depend 100% on doctors making a referral to them. And how does a laboratory distinguish itself among the dozens of other laboratory options that are out there? Sometimes laboratories go too far in trying to attract referrals from doctors. So I've seen a couple of examples that I'm going to just mention because I think it's instructive. Going back probably 5 or 6, maybe probably longer, probably 8 years ago, I was approached by 2 doctors who had been approached by a biodiagnostic laboratory, which is now most people know the name biodiagnostic lab because it was the subject of a huge criminal investigation in New Jersey. The doctors telling me that the lab wanted to rent space from them, sublet space from them, and the lab also wanted to pay them to become medical directors. And I looked at the relationship and I said, this doesn't smell good because what they're paying you doesn't seem to line up with how much time you're going to be spending as a medical director. And they're subletting space from you, which doesn't make sense. It's a huge amount of space they're all looking to sublet, and they're looking to sublet it 5 days a week when they're only going to use it a couple days a week. And one of the doctors said, Dan, everybody's doing this, and you're telling us we can't do it. You're preventing us from making money. And I said to him that there's a lot of room in Leavenworth prison for everybody, which is true. And the fact is, and Anthony will hit on this, there's a lot of schemes out there that involve a lot of people, and a lot of doctors are lulled into a sense of complacency or comfort, thinking, well, a lot of my colleagues are doing this. In fact, that's not a legitimate defense. As one of my former partners used to say, who passed away, John Maroney, ubiquity is not a defense under the law. And Anthony will get more into that discussion later. Another example for laboratories, just because it's such a prime example for us, is we have right now healthcare data is extremely valuable, and there's a large market now, particularly with the pharmaceutical industry, to buy data from medical practices. Specifically, for example, an oncology practice, which has huge amounts of data that allowed the pharmaceutical companies to do retrospective studies that establish the efficacy or non-efficacy of a particular treatment, and it's really valuable. It's truly useful. But I've had a number of instances where there were large laboratories that were looking to pay huge amounts of money for data from a subset of my clients, and the concern I had with that, because my clients obviously were thrilled. In one case, my clients were looking at potentially more than $1 million of annual revenue from the data acquisition. The first thing I said was, well, this lab is obviously looking for referrals from the practice, so we have to make sure that the amount that the lab is paying for the data is fair market value. And how do you determine what fair market value is for data? The value is in the eye of the beholder, essentially. It depends on what that buyer is going to use the data for. That determines the value. So I then began to dig deeper and ask the lab, well, what do you use the data for? Are you actually selling it, reselling it, or are you just warehousing it? Is this just an excuse to pay doctors to make referrals? Which in this case, it was not. It was a legitimate attempt to build a data warehouse, to curate the data. But we ended up getting a third-party valuation who came up with a number for the value of the data that was different than what the parties had originally considered. It was lower, and obviously no one was thrilled about it. But at least the goal is that everybody stays out of jail. So this is an example where it looks like a regular transaction to the parties, and the parties don't have the intent to defraud anyone or overutilize care or refer unnecessary lab procedures. There's no intent on either side, but parties could easily have gotten themselves into a huge problem if they hadn't evaluated this in a deeper way. So any contract with a diagnostic imaging company, Diagnostic imaging companies have been the subject of intense scrutiny, not as much as labs potentially, but certainly a lot. And there are a lot of bad actors and good actors in that industry. Um, One of the things that I've seen a number of times in my practice are mobile imaging companies that seek to go to a doctor's office and allow the doctor to effectively bill for the mobile imaging and then pay a percentage to the mobile imaging company. And the mobile imaging company basically creates a turnkey operation for the medical practice. The medical practice doesn't have to pay anything unless they generate income from this venture. The doctor doesn't have to pay for the equipment separately, doesn't take financial risk, doesn't have to pay for the techs. They're all supplied by the third party. The problem with this transaction is that the OIG has created a fraud alert several years ago, a bunch of years ago. Yeah, I call it the suspect joint venture fraud alert. And the suspect joint venture fraud alert essentially says that when you have a service provider like an imaging provider that normally bills for the service on their own and depends on the referrals that doctors make to them in arm's length transactions, when you have that type of service provider that provides a turnkey, no risk situation for a medical practice and allows the medical practice to do the billing and then receives something like a percentage, the OIG said that's tantamount to the imaging company just paying a kickback to the doctor. Because essentially what's happening is the imaging company is just allowing the doctor to bill for a service, 100% of which is being covered and paid for at the sole risk of the imaging center. The doctors are taking no risk. I bring this to your attention because there are ways to sanitize these relationships beyond the scope of this discussion, but there are ways to make this relationship appropriate. And I've seen well-intentioned parties and try to enter in these types of transactions because they seem logically fine. Doctor's billing, doctor's not referring to the imaging center because the doctor's doing the billing. It's easy to fall into that trap of thinking that you're okay when you're not. And very often all it takes is someone to shed light to both parties on the risks and then readjust the transaction, so the doctor's taking more risks, so it complies with the various safe harbors. Home health, infusion, these types of things are very common sources of investigation because there's a lot of potential fraud in these areas. I'll tell you, in infusion, one of the things that I'm seeing more frequently lately is infusion companies that are providing medical practice patients with vitamin therapy, for example, or hangover therapy. And a lot of people think this isn't even this is even a healthcare service, but in fact, most states view this as the practice of medicine. So it has to be viewed as the practice of medicine like anything else. You're essentially diagnosing or treating an illness, whether it's approved by the FDA or not. That's essentially what you're doing here. This is not like a purely cosmetic situation. So these types of relationships often involve an infusion provider who says, hey, we'll provide you with vitamin therapy, this turnkey thing, give us a percentage of what you collect, all that stuff. One of the problems with any situation where you have a non-provider splitting fees with a provider in any sort of percentage arrangement or anything other than direct fixed fair market value for the service that the non-clinician is providing. Anytime you have that shared fee relationship, your antenna should go up. It's very, very likely there's a problem with that. And that problem can often be solved if both parties are legitimate and are looking to solve that problem. So I'm going to just talk about one or two of these, and then I'm going to let my partner Anthony speak. But anytime you're offered a medical director or consulting arrangement, viewed by legal counsel and should be considered carefully. Very often, medical director consulting arrangements are offered by parties that are seeking referrals, and those parties are always willing to pay more than fair market value or pay for things that aren't really being done legitimately. I can't tell you how many times I've evaluated relationships, whether it be with laboratories or hospitals or imaging centers or surgery centers that are paying a medical directorship fee. I had a surgery center once that had 7 medical directors, each one getting a significant amount of compensation. You don't need 7 medical directors. So obviously there was an attempt there to pay in order to induce the physicians not to go elsewhere and bring their patients to that location. Any arrangement where you're potentially getting a speaker fee. There's been a huge investigation of a company called Insys, which produced a drug called Subsys, which is a fentanyl type derived drug, and doctors were receiving speaker fees to essentially promote this medication. Many of these doctors, I know some of them, I know of some of them. Virtually all of them were criminally charged, first of all, just for receiving a speaker fee. Because, and even though many of them really legitimately thought they were speaking, they'd come to an event, there'd be 3 doctors there, and they'd be paid, $60,000, $70,000 a year, which is another thing. Most of these arrangements don't involve life-changing money for doctors. They don't involve, millions of dollars. They involve tens of thousands of dollars, which doesn't make, in most cases, a lot of difference to the doctors. But the liability and the criminal exposure is still any independent contractor relationship as opposed to an employment relationship. Employment relationships are typically protected by stronger exclusions and exceptions than independent contractor arrangements. Any independent contractor arrangement should be reviewed and considered for regulatory issues, not just business issues. Any part-time employment relationships, some of them are totally fine. Many of them problematically they're a problem because sometimes a part-time employment arrangement is really a hidden independent contractor arrangement and not truly a bona fide employment arrangement. So they need to be reviewed in many cases. I'd probably go on with these things, but the point is you have a general sense that these kinds of business transactions with third parties, particularly between a physician and a non-physician, have to be considered very seriously. And now my partner Anthony will talk a little bit about some of the more painful things involved in these types of arrangements, namely, the process of investigation, how to avoid, and how to deal with it. Anthony, I'll turn it over to you.
Well, thank you, Dan. You have so many years of experience in this space. I really appreciated your insights and flagging of the various types of arrangements that present increased risk within what is admittedly our very highly regulated healthcare industry. And thank all of you for joining us today. I'm humbled to say that we have numerous professionals from all types of healthcare businesses across the country joining. And while the laws in your specific areas of practice and states and jurisdictions may vary, we've designed this webinar so that it is equally applicable to all practitioners in whatever discipline they may be in. So for this section of the webinar, what I'd like to do is to essentially talk a little bit about what we mean when we refer to the concept of risk, and then give you some strategies that will help you manage and potentially reduce the level of risk that is inherent in some of the transactions that my partner Dan flagged for you in the prior section of this webinar. But that being said, I think we should all acknowledge right up front that with opportunity comes risk. Therefore, as you are looking to innovate, to capture those market opportunities and grow your practices, your businesses, you will naturally need to accept a certain level of risk. So today's webinar is designed to assist you in answering the question, how much risk are you comfortable taking? So just in terms of the background, my experience in risk management comes from a variety of perspectives that I've been lucky to have across the course of my legal career. I formerly served as the Chief Compliance Officer for United Health Group, probably the largest healthcare company in the world. And before that, I worked for McKesson in a compliance role around a very front page headline grabbing risk that is relating to opioids. And I was able to kind of join industry at those companies from the Department of Justice, where I had served for approximately a decade in New Jersey. So I bring the perspective of government, industry, and private practice, where I am today as the chair of Frier Levitt's white collar and government investigations group to bear in helping my clients evaluate what is the risk, how do we put our finger on it precisely, and how do we manage it. So when we talk about risk, it's fair to say that it exists on a sliding spectrum. The most conservative businesses would prefer not to even receive a subpoena to get involved in any investigation, no matter their role in it. On the other hand, moving to the right, an area of potentially more increased risks are private lawsuits. But those risks are contained insofar as the lawsuits, Jane Doe versus John, whatever it may be, are typically limited to money damages. So when it comes to licensed professionals, it's interesting insofar as I put the administrative consequences of potential violations to the right of private lawsuits, because in this context, in the context of licensure, there are some very severe sanctions through the administrative process, such as suspension and revocation proceedings that are far more consequential than simply a lawsuit involving money damages. Whereas if you're not licensed, you might transpose those two buckets. And finally, obviously, in terms of the criminal consequence, the worst case scenario, incarceration, you want to kind of understand and appreciate with respect to the latter half of that scale, that wherever your business bumps up and so-called touches a government, whether it be a regulator or an agency, billing to Medicare, for example, those are the areas that you'll want to appreciate, give rise to heightened scrutiny and attention. So I'm often asked by clients, well, how do I know if I'm being investigated? And while I would like to answer that question, I can't do so in most cases with a reasonable amount of assurance. However, what I can tell you is that once you learn of an investigation, whether it be through any of the mechanisms shown here on the screen, search warrants, arrest warrants, whatever it may be, you will know that it is far too late to do much of anything about it. So what you need to do is to think about from the perspective of moving backwards, assuming, in my world, I always assume the worst case scenario and prepare my clients to address the so-called worst case scenario, so that we know what type of story that we will be able to tell when we decide whether to proceed with a transaction and how good that story will be. So in my world, the least desirable response is to have no response at all for that day when the questions come. In the healthcare industry, the number of eyes and the amounts of money at stake make it a very fertile ground for enforcement, especially considering what is essentially a public-private partnership between government agencies and regulators and whistleblowers who are incentivized by large bounties to report potential misconduct. So speaking to that a little bit, you should appreciate that by far the most numerous and significant leads, investigative leads that is, are provided through reporting by whistleblowers under what is referred to as the False Claims Act. There's a federal statute, most, if not all, well, it is most, it's the far majority of states have state analogs that mirror the federal False Claims Act. So that would be applicable to, for example, Medicaid billing. And so under those statutes in 2021 alone, just last year, at a federal level, the Department of Justice obtained more than $5.6 billion in settlements and judgments, and that's the second largest annual total in history and the largest since 2014. And you have to appreciate, given the restrictions and President Biden's new priorities, there is going to be a significant ramp in that activity in the years to come and larger recoveries to be reported. So from your perspective, I just want to give you a little bit of insight into the process. Under the statutes, a so-called whistleblower will file a complaint, a grievance, under seal with a U.S. Attorney's Office. And it doesn't necessarily have to be in your state or anywhere close to you, because the statute provides that the whistleblower can report his tip to any United States Attorney's Office in the country. There's nationwide jurisdiction. And you should know, and I think you've probably understood from headlines, that certain U.S. Attorney's offices around the country cater more to the relators bar, the so-called whistleblowers, than others. So for example, Boston, that's a perennial office that has large amounts of whistleblowers that are providing insight to those prosecutors there. But the insights and reporting that is provided in the cases that are filed under seal can relate to conduct that's occurring anywhere in the country or its territories. So once the government receives that case, let's say a case is filed against you, Mr. Relator versus Mr. Doctor. If they receive it, you're not going to know about it. The government is permitted a period of time that can range from a matter of months to literally 5 or longer years to investigate the complaint the whistleblower has made. And that investigation may spin off into any number of avenues. There could be people charged with potential criminal conduct if the conduct is that severe, as well as other types of cases that are brought before you even have any idea that someone has sued you. And it could be resolved civilly or criminally, as I said. Obviously, at some point, you will learn of it, but that is well down the road. So that's the first bucket there. There's a secret underground process that is underfoot day in and day out of whistleblowers reporting people and the government looking into it. And only when the government decides where it wants to go in terms of resolving the investigation will anyone learn of the case that's been filed under seal and what the allegations are, so as to permit yourself to defend against those allegations. The second source of investigations, and we're seeing more and more of this these days, given the budget shortfalls that are in place across the country, given the damage wrought by the pandemic, higher levels of adoption of referrals, especially by the state MFUCO agencies, they're called Medicaid Fraud Investigative Bodies, from payers and PBMs, other entities in the healthcare chain. So for example, when I was at United Health Group and overseeing compliance across the entire $250 billion enterprise reporting to the board of directors, I was responsible for managing a very robust SIU, it's called, is a special investigations unit made up of former government agents, FBI, OIG, and the like, who every day in, day out, poured over data and billings and different types of information that's available through the process in deciding, obviously the insurance companies are incentivized to stop potential fraud, waste, and abuse. In prior years, only the biggest cases were picked up by regulators, but now increasingly these days, as I said, referrals are being picked up on a lower dollar amount and more frequent basis by the states. Moving to the right, data mining is an area in which the government is continuing to become more sophisticated every day, though data mining in itself is typically used more for furthering an investigation that has come in and that has come to the government's attention from other means. That being said, there are certain areas, Dan called out labs and relationships there. So, for example, in the cancer genetic testing space, the government has a very highly developed playbook that it rolls out across the country. It has a very structured way of proceeding with respect to investigations in this area, and is very active given the amount of reimbursement at issue with these expensive tests. And so finally, the government has any number of cooperators and informants that in fact may be employed by your organizations or attempting to cozy up to you in the hopes of developing investigative leads. And that's an area in which the government has also developed resources, and that results in investigations. So if there is an investigation, the central focus of the inquiry is always to determine what happened and why. So this relates back to my advice about thinking in terms of the end game. Go to the end before you start. And what type of story is going to emerge? Did something happen accidentally, potentially due to human error or lack of supervision? On the other hand, did someone do this intentionally and with a bad intent? Regardless of the type of investigation, we're talking about civil, administrative, criminal, it doesn't matter. The bottom line is, the question to be answered is, what is the so-called mens rea? What is the mental state around a particular course of conduct? Therefore, if something wrong occurred, how does one show that they did not intend for that to occur? For example, the government has billed, let's say, $5 million for non-reimbursable items or services. Happens day in, day out, all the time. But why? Why in this particular circumstance did it happen? Is it because someone is attempting to lie, cheat, and steal? Or far more likely, is it because the items billed were actually believed to be reimbursable? Someone really truly believed that in good faith, these were appropriate claims to submit to the government. And it's that belief, an honestly held, good faith belief, that is a complete defense to any allegation that something was done knowingly and intentionally. And what I have here is just some instructions that a judge would give a jury in a case, a civil or criminal case, about what needs to be proven, and in terms of the defense of good faith. So you can read that and refer to that. And so just kind of leaning into that so-called good faith defense, I think that all of you appreciate that reliance on attorneys is one way in which to demonstrate that a particular course of conduct was undertaken in good faith. And now that is absolutely true, but I want to make sure you are aware there are a number of very specific caveats that are necessary to what I just said. So specifically, if you're going to seek counsel's advice, you have to follow it precisely, or the consequence at the end of the day will be worse than not obtaining that advice in the first place. Think about it. If an attorney says you have to do it this way and it's not done that way, that goes to, that raises questions about why it was not done, when there's specific advice such that that individual knew this was the proper way to do it, as opposed to, well, it's a little ambiguous, a little bit unclear. So if you have not followed the attorney's advice to the letter, you will not be able to use it as a so-called sword and shield. That is, you cannot offensively use it and say you relied on your attorney where it's helpful to you, and in that regard, waive the privilege, turn over information that is otherwise within the sanctity of your relationship with your attorney offensively, but at the same time say, well, no, I'm not going to turn this part over where it's not helpful. This is an all or nothing proposition. So finally, this is something that I'm going to talk about in terms of the practical strategies. You should note that in order to rely on an attorney, it has to be your attorney. You have to receive the advice in a privileged context through consultation with your attorney. Therefore, to be very specific, it's not enough where your counterparty to a transaction gives you a legal memo from their law firm or a different law firm in which that law firm concludes that everything is hunky-dory, this is no issue. You will not be able to cite that as a good faith reliance because that advice was not provided to you in the context of an attorney-client relationship with your attorney. So we've talked a little bit about how to establish a good faith defense and how to kind of answer questions that might arise through investigation. But ultimately, what I want to point out here is to put on my compliance hat and put aside my days as a federal prosecutor. Just how do we wind it back? How do we stop that event from occurring in the first place? And in my experience, the best way to do that is through the implementation and operation of an effective compliance program designed to prevent and detect potential misconduct. And I've laid out here in this slide kind of the benefits, the so-called business case behind compliance investment, because that's always a hurdle to kind of any decision in terms of why would we spend the money up front. And I think there's a true business case in support of an effective compliance program. And so in an ideal state, what that would mean is that you and your business would receive meaningful internal information, whether that be complaints, grievances, Dropbox suggestions, information through the exit interview process that will give you some insight and also encourage employees to bring to your attention some of these areas of potential risk, like marketing arrangements, so that they can be addressed and resolved prior to the information getting out to regulators in the first place. So at a minimum, a properly structured compliance program should negate an unlawful intent, provided it is built properly, it is staffed properly, it is overseen properly, and assuming some level of disclosure of the conduct to the compliance department. And so here, I advise clients all the time on a variety of strategies and techniques to kind of promote the internal flow of information so that it can get to your attention, you can address it, remediate it, and essentially reset the tables before it gets outside. And then if it gets outside, you have a different look than had you not known about the information. And so ultimately, when it comes down to it in the quick, that's the benefit of a good compliance program. So just to summarize at a very high level, if you have concerns, do something about it. If there are activities on a historical basis, don't let them lie and kind of hope, because hope's not a strategy in my world. That's never effective. Hope that they don't come to light. There are programs and mechanisms that we can use to disclose that conduct to the government, to receive favorable treatment, perhaps no sanctions whatsoever in certain cases, and in most cases, the most severe sanctions can be taken off the table through disclosure potentially, or even short of disclosure, as I referred to it before. Can we reset the table? Can we, change the tablecloths? Can we change the centerpieces so that it looks completely different if down the road it were to come to outside attention? Should we put money in a trust account and hold it so we can show, look, there was no intent to take this money. If someone thinks it was improperly received, it's here, have at it. And then, act proactively on a forward-looking basis rather than reacting to a scenario where once you're in a position to react, it's probably too late. So in that respect, you should appreciate that when you are presented the opportunities, such as my partner Dan described, and you're looking around the industry and you see everyone around you capturing the opportunity and going down a certain road, whether it be, let's say, there's some enforcement recently around foot baths and foot baths that are going out from pharmacies, and there's medications, a 30-day supply that you drop in foot baths. And the government is now kind of catching wind of it, and it has put some people in jail, has brought enforcement actions against others. So just because everyone is doing it is absolutely the reason you should be more cautious, not less, because when the day comes that the federal government or state governments actually get around to acting, and there's a tail there. They're not on top of the thing as it's occurring. They often don't learn of certain types of so-called schemes until years after the fact. And so if you go down the road of everyone's doing it, it's true. In certain industries, everyone is doing something, but all that means is that you're essentially putting yourself in a position of speeding like everyone else. You're exceeding the 60-mile-an-hour limit, and you have to embrace that. If you are exceeding the limit, you have to appreciate that you might get a ticket, just like the guy in the lane next to you, the guy in front of you, the guy behind you. Everyone's going faster than 60, 65, whatever it may be. So what are you going to do if you do go down that road to protect yourself? That's where you really have to lean into it and kind of think ahead and think more than everyone else around you, how you're going to protect yourself, and appreciate the likelihood that the fact that everyone is doing it only means that it's more likely to receive scrutiny by the government. And we've talked a lot about the government, but you should not neglect the fact that private pay is also important, especially from the perspective of private pay making the referrals over to government, and then the government kind of digging into whatever is referred to it. So that brings us to the portion of the presentation where you folks can provide questions through the chat function. Happy to answer in the last 10 minutes that we have remaining. Whatever questions you have today, if you can't think of any you have now, but something comes to you later, don't hesitate to contact us, reach out. Love to talk about these issues. It's not just our jobs, it's something that both Dan and I, having done it for so long, actually enjoy and really kind of value in so far as being able to help folks like yourselves or others.
I think one of the questions that was being asked is what to do if you're involved in a contract that wasn't reviewed by counsel, you're already involved in it. What can you do about it if you're concerned about it? I'll briefly say that any contract that turns out to be in violation of any law may be deemed null and void because of that. So it's reasonable to have legal counsel review contracts even after the fact. Obviously, you'd like to have contracts reviewed before they're signed, but it's certainly better to have them reviewed at some point rather than not reviewed at all. And if there are legal problems, and I've dealt with this before, you can go back to the drawing board and try to fix those issues. Certainly don't be satisfied with the fact that you've signed it already.
Now I do see some questions, in fact. So one of the questions that has been asked is, how does the department determine, given that sliding scale, whether something is a civil matter or a criminal matter? And I have to say that you can ask a lot of attorneys who've worked for the government that question, and a lot of them will have different answers. But there are a few hallmarks that I think are indicative of criminal treatment more frequently than civil treatment. But that's not to say the same hallmarks interpreted in different ways could also be just as prevalent in terms of civil enforcement strategy and investigations. And specifically what I'm referring to there is, one, patient harm. if there is a compromise with respect to patients, patient safety, patient health, you have to appreciate, especially the more vulnerable segments of our population, the elderly, the sick, the poor. If there is an abuse of patient harm or safety through the potential abuse through a given course of conduct, you have to assume the government will be more interested in sending a message. And those are the criminal cases where they want to send that message to get the deterrent effect that the conduct at issue will result in the more severe sanctions. On the other hallmark, I touched on it before, that is large dollar amounts. So for example, you have arrangements with marketers related to cancer genetic testing. The reimbursement on those tests is in the tens of thousands of dollars at certain points, given whatever it may be, but ultimately they're very expensive tests. And so you see a lot of enforcement in that area because there's high reimbursement amounts. Whereas, I think we would be remiss if we said, well, those same types of arrangements and structures between independent contractors and independent labs, we don't exist in the urine testing or drug testing space. Well, that's preposterous. You see the enforcement in cancer genetic testing versus the urine testing because of the amount of reimbursement in that issue.
Anthony, there's a couple of other questions I'll just bring to light. One is that what is the possibility of having a letter issued by Medicare that a referral will be considered legal? I think what's being asked here is, can you get opinions? The OIG does provide advisory opinions. We are in the process of requesting one now on behalf of a client. It's an excellent process. It makes sense in certain circumstances, particularly where it's a significant, sizable transaction. You're concerned about the legality of it, and you're not going to do it unless you get some positive response from the OIG. Typically, this happens in a situation where a transaction doesn't squarely fit within a safe harbor, so there's no certainty. And we often recommend that our clients proceed with an advisory opinion before they embark on a risky matter. And there's an art and a science to drafting a request, but it's you're typically dealing with pretty smart attorneys at the OIG level, and it can make a lot of sense to do it. However, obviously, you have to disclose all the facts with complete accuracy. If you leave anything out that's material, if something changes, the opinion is no longer valid. There was another question I think Anthony's probably better suited for you, which is some lawyers are giving advice, but their clients are still being found at fault, occurring at very large firms specializing in healthcare. So, it's an interesting question. I mean, how do you deal with a situation like that, or what's going on, or what in what circumstances might an attorney's advice not be sufficient to protect you?
Right. So, certainly that's unfortunate. In the first instance, I mean, that's not consistent with any client's expectations. You go to an attorney, you consult an attorney because he or she is an expert in that matter, and you expect that you will be able to rely on the attorney. So those cases, I believe, are probably the exception to the overall rule. And there may be more specific circumstances around them in particular that kind of resulted in clients being found responsible, even though they were following what they believed to be the attorney's advice. Now let me say, that being the case, the attorney reliance defense is ultimately a very difficult defense because it essentially concedes that everything happened. And oftentimes, the devil is in the details. Oftentimes, the facts are not as the government would like to portray them, or as some regulator or insurance agency would like to portray them. The facts are critical. And when you talk about an attorney defense, you've essentially conceded that this happened, this occurred, but your answer is that yes, it occurred. However, I thought it was okay. And so to succeed, ultimately, you are far down the road of, let's say it's before a jury. I've gone before numerous juries in the course of my career as a federal prosecutor, working for a law firm, trying cases in Manhattan and in New Jersey in the federal courts. And what I can tell you is that the vast majority of juries make up their minds very early on in the case. And so when it comes to someone getting on the stand and saying, yeah, this all happened, but I thought it was okay, that's only long after the government or opponent has presented all of the evidence that this occurred, that there was indicia was done improperly. And the jury, 9 times out of 10, I think it's actually 80% within the first, hours of the case, if not minutes, make up their mind. The jury has already concluded something was a problem, and they're largely dismissive of the defense because of the context in which it's raised. So, while attorneys' advice is critical, the best ways in which those outcomes are achieved in terms of preventing the scenario I just described is when you have the opportunity to bring it to the attention of a regulator and you use that as leverage, not necessarily to kind of just be your last card to play at a trial, but well in advance of that when you're negotiating with regulators so that it doesn't ever get there. Either it's a favorable settlement or no trial at all, because you have that and you can show that early on in the case. But ultimately, whether you can convince the jury of it, I mean, it's my experience that the reliance on counsel is best used for leverage to resolve your case early on in a manner that's most satisfactory because you have that in your pocket.
Thank you, Anthony. I think that just about wraps up our time for today, and I want to thank everybody for joining us. Copies of the webinar are available. Just request them and we'll send you a link. And thanks everyone for your time and have a great day.
Thank you.